What does it mean for a corporation to own the commercial meaning of a place? Patagonia is a vast region spanning Chile and Argentina. It's also an outdoor brand, one that has spent more than 50 years turning the region's name and imagery into a symbol of wilderness and adventure. Now, Patagonia Inc. is suing drag queen and climate activist Pattie Gonia for trademark infringement. But beneath all the legal questions lies a more complicated one. How did a U.S. corporation acquire the power to control the commercial meaning of a place to begin with? Welcome back to Art of Citizenry, where we unpack the systemic power structures that have shaped culture, politics, and policy. I'm your host, Manpreet Kaur Kalra. I'm joined by Professor Alex Roberts, a professor at Northeastern University School of Law and the College of Arts, Media, and Design. Together, we explore the mechanisms that underpin trademark law, the colonial logic of commodification, corporate personhood, and what it would mean if nature was granted similar rights.
I teach classes in intellectual property, trademark, and entertainment law. I also teach a course on trademarks, advertising, and endorsement in creative industries to undergrads and non-law grad students. My research is mostly in trademark and advertising law, so I've written about some core trademark doctrines like failure to function and acquired distinctiveness, and then some fun topics like poetic devices in trademark law, hashtags as trademarks, and trademark registrations for the names of minors without their consent. And I have an article forthcoming on personal brand as intellectual property. And then on the false ad side, I've written about influencer marketing, multi-level marketing, and marketing products as dupes.
In January 2026, outdoor brand Patagonia Inc. filed a lawsuit against Win Willie, climate activist and drag queen better known by the stage name Pattie Gonia. In September 2025, Pattie applied to register her name, Pattie Gonia, as a federal trademark with the U.S. Patent and Trademark Office across multiple categories, including apparel, merchandise, marketing, community events, and promoting environmental sustainability and equality. Patagonia Inc. is seeking $1 in damages plus legal fees, which are sure to be significant. But the real stakes are injunctive. The company wants the court to block allegedly infringing merchandise. This could include merchandise with Pattie Gonia written on it, prevent Pattie from obtaining the federal trademark registration she applied for, and restrict commercial use of the name that Patagonia says could cause confusion or dilute its brand. At the crux of it, this case calls us to interrogate how much control a corporation can claim over a name borrowed from a real place.
So Patagonia has sued Pattie for trademark infringement and trademark dilution. To succeed on a claim of infringement, it needs to show that Pattie's uses will create a likelihood of consumer confusion. So in other words, that some people who encounter the products she sells will think they come from Patagonia, or they're being sold with that brand's authorization or permission, or that there's some kind of collaboration going on. And then for the federal dilution claim, Patagonia needs to show that its mark is famous among the general consuming public of the United States, so basically a household name, and that Pattie's mark is so similar that it kind of blurs or harms the distinctiveness of the brand's mark, like its ability to be a source indicator, to be the only Patagonia out there, even if it doesn't confuse anyone. There's also a state dilution claim in there. So for that one, Patagonia just needs to show fame throughout California and that same kind of blurring that I just described.
One thing that really stood out for me is that Patagonia Inc. is not the only entity with a registered trademark containing the word Patagonia. A search in the USPTO database turns up a number of marks that use the name in some form or capacity. So why did Pattie Gonia's application trigger such a response from Patagonia, the outdoor brand? Another piece of the puzzle is the narrative, well, we had to, our hands were tied. So when companies invoke a so-called duty to police, is that a genuine legal necessity or a strategic justification for expanding the boundaries of corporate ownership?
I think there's some speculation that it's Pattie's not only sale of merch, but her application to register her trademark that set off some alarm bells at Patagonia and led them to take action because it shows that she's really using Pattie Gonia as a trademark and not just kind of as a stage name, right? So there's some speculation that maybe Patagonia kind of has to sue or it risks losing its trademark. But I think there's a lot that gets misunderstood about that, what they call the duty to police, right? So there's this idea that's kind of popular with lawyers and with the public that trademark owners have a duty to police their marks, that if they don't sue or send cease and desist letters to everyone that might be considered infringing, they could lose their trademark rights or they could have a harder time enforcing when it really matters. And we see a version of that in genericide cases when a mark like thermos or escalator is in danger of becoming a regular noun that everyone uses as the name of a whole category because people no longer view it as a brand. In those cases, not taking action when others are using your brand name in a generic way can have consequences. So like if Dunkin' and a bunch of other chains start using Frappuccino as a drink name and Starbucks doesn't do anything, eventually it could become the case that people view Frappuccino as a category of drink, not as a branded product that they can only get at Starbucks. But that's not really the risk here, right? I don't think Patagonia is in any danger of becoming like a generic term for athletic apparel. It's also true that in any specific example of infringement, a trademark owner that waits too many years to take action can lose the ability to do so because a court will say they've sat on their rights. You knew that this other user was out there and you did nothing for a decade, so they kind of expanded and built up a fan base and you're going to sue them now. It could be too late. But this idea that a mark owner has to come after everyone who uses anything similar or else jeopardize their own rights, I think that's really overblown. For most mark owners, they get to choose when to sue based on the specific circumstances. So no one who espouses this like duty to police theory seems to have examples of cases in which a judge said, well, yes, this defendant is creating a likelihood of confusion with your trademark, but because you didn't sue these other infringers in the past, you can't enjoin this one today. Like, that's not really a thing. So what really matters for an infringement claim is likelihood of confusion. The plaintiff is either able to establish a likelihood of confusion or they're not. So when a big corporation says, oh, we don't want to sue you, but our hands are tied, we have to, trademark law makes us, they will always get side eye from me. I think they're just exaggerating what the law requires of them.
And I feel that this is where drag itself becomes part of the legal story. Patagonia does not just sell outdoor gear, it sells an identity. The explorer, the adventurer, it's gained this nickname, Patagucci, for a reason, bougie outdoors. And over recent years, it's become increasingly synonymous with tech culture. You have your company branded nano puff vests all over Silicon Valley. Patagonia sells a performance of ruggedness. And I suppose that is what drag exposes, an art form that shows us that identities we treat as natural are often socially constructed through clothing, symbols, branding, etc. So that said, some years ago, Pattie created a sticker featuring a person climbing the mountain range in Patagonia's logo, and the person was wearing heels. So how does parody function as a defense in trademark law?
Yeah, in the drag queen community, it's common to choose a punny name or maybe a name that references or plays on a well-known brand or celebrity name. And parody and expressive use get a pretty robust First Amendment defense in trademark law. So we have these cases like Chewy Vuitton, which is a dog toy, and the Barbie Girl song, right? Courts will acknowledge that when a use is designed to convey a parodic message and it uses a well-known trademark to convey it, that's a great defense against a claim of infringement or dilution. There's kind of this carve out for those expressive parodic uses. But there's a catch here. And the Supreme Court made it really clear recently in the Bad Spaniels case. The catch is that parody use can't also be a trademark use. So when Pattie applied to register her mark as a trademark, she told the USPTO, Pattie Gonia is my trademark, right? I'm using it as a source indicator. And she basically forfeited the ability to take advantage of that defense. It's still true that courts could still find that the fact that a use is parodic makes confusion less likely. right? Consumers will understand the reference and they won't be confused. But she doesn't get that kind of safe harbor that she could have gotten if she was maybe only using Pattie Gonia as a stage name.
In 2023, the Supreme Court decided Jack Daniels v. VIP Products, better known as the Bad Spaniels case. So VIP Products sold a squeaky dog toy shaped like a Jack Daniels whiskey bottle, swapping the labels Old Number 7 for the Old Number 2 on your Tennessee carpet. Basically a poop joke. Jack Daniels sued, and VIP argued that the toy was a protected parody under the First Amendment. But the court ruled unanimously that the special protection for expressive parodic works doesn't apply when the parody is itself being used as a trademark because VIP was using Bad Spaniels to market and sell its own toys. I think it's also important to clarify what trademark registration actually protects. There can be this tendency to assume that because Patagonia registered the name, it somehow owns every use of the word Patagonia. But that's not how it works. You have to register your trademark use with particular goods or services. And so trademark rights are not absolute. That said, as someone who has studied trademark law so deeply, can you tell us a bit about where a company's rights actually extend to and where do they stop?
Yeah, a trademark involves rights in a word or logo or some other device in connection with specific goods or services. So the mark isn't just like Adidas or Monster. The mark is Adidas for sneakers or Monster for an energy drink. Patagonia has registered its word mark and logos in connection with a number of things. So clothing, retail services, education, entertainment, books, camping equipment. So its rights do extend fairly far, but I think it's important to remember that multiple companies can use the same term or phrase for different goods. So we can have Dove chocolate and Dove soap. We can have Delta Airlines and Delta faucets without necessarily confusing anyone. So consumers can understand these things use the same word as a trademark, but they come from different brands, right? And in fact, the more basic or the more descriptive a word, the more likely that multiple businesses will use it as a trademark, and the more likely that consumers can handle distinguishing those from each other.
Patagonia is a real place, a well-known, vast region. So how does a company acquire trademark rights to a geographic name to begin with, especially a place to which it has no connection whatsoever? It's not like Patagonia is called Patagonia Apparel. It is simply just the word Patagonia. How is that possible? And as an aside, I can't help but think about the irony here. A corporation built its identity around a name borrowed from a real landscape and is now asking a court to decide whether a climate activist borrowed it too much from them.
The first thing to know is that in the United States, rights are based on use. So there are some kinds of trademarks that are protected automatically as soon as use begins. And then there are other kinds of marks, especially descriptive ones, that are only protected when they've been used and marketed long enough for consumers to understand them as source indicators. And then there are other kinds of marks that are completely barred from protection. So we often talk about registration, but registration is optional in the US. It's really supposed to just be like a formal reflection of those rights that are based on use. And then when we think about trademarks that are or include place names, we're going to ask first whether the goods or services actually come from that place. So for example, if the mark is Vermont's Fanciest, for maple syrup made in Vermont, or California Containers for containers manufactured in California, then those are going to be treated like other descriptive marks, right? The thing they describe is where the goods come from. They can be protected once they acquire distinctiveness, once people come to view them as brands. But on the other hand, if the mark is or includes a place name and the goods or services don't come from that place, it can be deceptive, especially if consumers would believe the goods come from the place and if that deception or that misdescription would affect their purchasing decision. So if you call your syrup Vermont's fanciest, but it comes from Canada, and consumers might say, well, we wouldn't have bought that if we knew where it really came from. Basically, you lied to us, right? So those geographically deceptive marks are barred from registration. They can't be protected. So then the question would be, where does Patagonia fit? Certainly, it's a recognized geographic term. Like, it's not so obscure that nobody would even know it as a geographic term. But probably consumers don't actually expect that the clothing is made there. So some people think that would make the mark arbitrary, right? An arbitrary mark is like penguin for books or strawberry for clothing.
Trademark law sorts brand names on a spectrum of distinctiveness, and the strongest protection goes to the most distinctive names. An arbitrary mark is an everyday word that has absolutely nothing to do with the product it's attached to. The classic example is Apple. Apples are fruit. iPhones are not. The word is common, but using it to sell computers is completely random. And that randomness is exactly what makes it so powerful. Because the word has no natural connection to the product, the only reason you associate Apple with technology is because of the brand itself.
But I think there's another way to look at this, which is it's still a geographic mark. So it should have been treated as geographically descriptive, right? It's trying to say something about the goods, even though it's not where the goods are from. And I think acquired distinctiveness should have been required for registration. I went to pull up the registration earlier today. The very first registration was from 1982. So I couldn't get access to as much background as I can with marks that are filed more recently. So I'm not exactly sure how the USPTO treated it when it was filed. Certainly it has substantial secondary meaning at this point. Geographic terms and place names are eligible for trademark protection. We just kind of pay careful consideration to this question of, is it actually accurately or inaccurately describing or implying something about the products?
As we've established, Patagonia is not an invented word. Yet Patagonia's lawsuit describes the mark as, quote, fanciful, a category generally reserved for made-up terms and afforded the strongest trademark protection. So a word with a history, geography, and meaning entirely independent of the company is being treated for trademark purposes, almost as though the corporation created it. How is that possible?
Yeah. Patagonia, the word mark, is in no universe fanciful, which exactly as you say, fanciful is a word that is made up for the sole purpose of being a trademark. It is true that some cases, including the oldest case on this topic, groups fanciful and arbitrary together in a single category. So in Patagonia's defense, they could tell you we're technically referencing this double category when we describe the mark as fanciful and arbitrary. But certainly, no, Patagonia is not fanciful.
So in my interpretation, I'm not sure Patagonia is entirely arbitrary in this context either, especially if an arbitrary mark is defined as using an existing word in a way that has no logical relationship to the product. Because in my interpretation, Patagonia is a region defined by mountains, wilderness, the outdoors, and Patagonia Inc. sells gears built around precisely that world. So the connection may not describe the technical qualities of a jacket, but it certainly evokes the experience and adventurous culture the company is selling, which is why I feel even the arbitrary claim feels complicated. You mentioned acquired distinctiveness. My understanding is that acquired distinctiveness happens when, through years of use, marketing, and consumer recognition, a term that did not originally point to a particular company eventually comes to identify that company's goods or services over time. So is that the stronger explanation here? The company spent years and many marketing dollars building such a strong association that many consumers now hear, quote, Patagonia, and think of the brand first.
Acquired distinctiveness, which is also called secondary meaning, is when consumers get used to seeing a trademark and they start to understand it to be a trademark. So for example, if you start with a descriptive mark like Weight Watchers for weight loss services or Tasty ice cream for ice cream, that wouldn't necessarily be seen as a trademark right away. It could just be seen as a descriptive term or phrase. But then once the brand invests in advertising and it sells a number of products and it gets some media coverage and it's around for a few years, then the public can come to see the mark as a mark, which we say as a source indicator, as a kind of signal that what the thing is doing, what the term is doing the work a trademark does, telling you who stands behind goods or services.
Acquired distinctiveness is especially important for place names that are considered geographically descriptive. You generally can't claim a place name as a trademark until the public associates it with your brand specifically, which is presumably how Patagonia became protectable for clothing. So a term can begin as geographically descriptive and over time become distinctive as a brand. The legal test for trademarks asks three basic questions. First, is the term primarily understood as the name of a generally known location? Second, would consumers assume the goods or services come from that place? And third, do they in fact originate there? The key distinction is that Patagonia is not using the word to tell consumers where its clothes come from. It is using the word to tell consumers who, as in which company, made them. Over decades, Patagonia has transferred the name of a real place into a source identifier, a word in the marketplace that points not to a region spanning Chile and Argentina, but rather a corporation. Sure, Patagonia Inc. does not own the place, but trademark law allows it to claim rights to the commercial meaning it has built around the name, the association between Patagonia and its particular goods, reputation, and effectively the brand.
So Patagonia, with 50 years of use and the sale of many millions of items, certainly has achieved secondary meaning, acquired distinctiveness. So then what does that mean for Patagonia, the place, right? A place where people live. It might actually mean the brand is so well known that when people hear the word, they think of the brand first and the place second. And in fact, some courts define secondary meaning that way. They say the trademark meaning becomes the primary meaning, right? It also might mean people's association with the brand start to shape their associations with the region. So if you ask young people what they think about Patagonia, their impressions of the place might be partly based on what they know about the brand, which is an interesting phenomenon.
And that brings us to the ethical question beneath the legal one. A corporation can take the name of a real place, build enormous cultural and economic value around it, and eventually gain the power to shape how the public understands that name, and by extension, the place itself. In some contexts, Patagonia may now evoke the company before it evokes the region itself. The brand has not only borrowed from the place, it has, to a degree, redefined the primary meaning of the word, despite the region of Patagonia predating the company. For generations, outsiders have imagined the region as vast, remote, almost empty wilderness, a landscape waiting to be explored. But that image is itself a colonial construct. Patagonia was never empty. It has long been home to indigenous peoples whose histories, relationship to the land, and continued presence are often erased by the romanticized mythology of untouched wilderness. That mythology is also enormously valuable. It allows Patagonia Inc. to sell more than jackets and outdoor gear. The name carries ideas of remoteness, ruggedness, adventure, escape. The company did not create those associations from nothing. It drew them from a real landscape and from a colonial history about that landscape, one that often makes indigenous people disappear while turning the territory into a backdrop for someone else's exploration. There is a profound imbalance in my mind here. A U.S. corporation has been able to convert the name and mythology of Patagonia into private brand equity, profit from those associations for decades, and then invoke trademark law to police how others commercially engage with the same name. So my question to you is that even if the legal rights are valid, how should we grapple with this ethically?
Yeah. I want to start with the kind of legal framework answer, which is that I don't think a mark owner of a geographic place name should ever succeed on a dilution claim. Because a federal dilution claim is really a claim that the famous mark owner has the legal right to ensure that when the public hears a word, there's only exactly one thing that they associate it with. So that might be like if you're Rolex or Pepsi, but if your mark is a common word or if your mark is the name of a place, this seems like a non-starter, right? And then the kind of bigger ethical question, that's a question that has come up around terms like Aloha, which I think a non-Hawaiian owned restaurant chain tried to register as a trademark, and then holiday names like Dia de los Muertos, which Disney tried to register, and tribe names like Cherokee and Pontiac, which of course car manufacturers have used and claimed. And some scholars have argued either that these things won't function as trademarks or that they shouldn't be allowed to be trademarks, or maybe that they should only be trademarks if they're owned and controlled by group members rather than outsiders. And I think those are difficult objections for trademark law to grapple with and accommodate, but I also think they're certainly conversations worth having. In some cases, boycotts have been effective, so leading Major League athletics teams, for example, to abandon marks and mascots. So I would be interested to hear the perspective of Patagonians.
Yeah, I agree. I mean, as I started thinking about this case, one framework that kept coming to mind is rights of nature. The idea that places are not simply resources available for use, but can carry interests of their own. It's this legal framework that recognizes rivers, forests, ecosystems, and other natural entities as rights-bearing subjects with inherent rights to exist, regenerate, and flourish. That marks a profound departure from the way most legal systems have treated the natural world for centuries as property, with laws and contracts generally designed to protect the rights of individuals and corporations. Around the world, we're seeing growing movements to grant legal personhood to rivers, forests, and ecosystems. The Wanganui River in New Zealand was granted legal personhood in 2017. Ecuador's constitution gives rights to Pachamama, nature itself. In Colombia, the Amazon was recognized as a subject of rights by the Supreme Court in 2018. I know that that body of law often sits within indigenous or environmental law, not trademark, but it feels relevant here, especially within the context of this conversation. So over the years, I've worked closely with many fair trade social enterprises where geographic names can reflect a real relationship with the place. A company might use Andean in its name because its products come from the Andes or are made by Andean artisans and are rooted in the knowledge, traditions, and culture of that region. In some ways, the geographic identification is used to honor the region the products originate from, the people who make them, and benefit from the purchase of those goods. Patagonia, however, is different. Through decades of marketing, the company has become so closely associated with the word, at a certain point, that starts to feel less like borrowing a geographic name and more like appropriating its meaning, exotifying a place far away, reinforcing Western visions of exploration, and effectively turning a place into privately controlled brand equity. So I'm curious whether there are examples that come to mind where communities or governments have pushed back against corporate efforts to commodify terms, names, or cultural identities.
This may be something that other countries are doing better than the U.S. has done. Public backlash and boycotts have led some companies to leave behind mascots like Uncle Ben for rice and Aunt Jemima for pancakes. Chief Wahoo was a baseball mascot. The Washington football team abandoned its name after really financial pressure from some major corporations involved with the stadium and things like that. public outcry led Disney to abandon its application for Dia de los Muertos. So that wasn't corporate pressure. That was kind of like individuals all over the internet saying, what are you doing? Don't you understand that this is offensive? And then in terms of litigation, so Navajo Nation sued Urban Outfitters over their unauthorized uses of the term Navajo in connection with clothing and jewelry. And they didn't win in court, but they ultimately settled. So I think we see sometimes that kind of collective action that's somewhat analogous for what you're envisioning here for geographic place names.
Many indigenous communities have long argued that Western legal systems transform relationships with land, culture, and resources into property that can be claimed, controlled, licensed, and excluded from others. Do you think trademark law sometimes reflects that same tendency?
Yeah, I think that's absolutely a great insight. Trademark rights aren't supposed to be property rights exactly. They're supposed to be kind of based on use in commerce. And as we were discussing, cabined to a very specific and explicit set of goods and services, but that's often not the way that they're treated. So we were talking earlier about dilution, the idea that if your mark is famous enough, if everybody in the whole country knows your mark, then you can keep others from using something identical or very similar, even if there's no risk of confusion at all, right? That's really more like a property right. That's this is my territory and I planted my flag and everybody has to stay off it completely. That also can happen sometimes too with the ways in which marks are policed, sometimes against expressive uses, against speech types of uses, against parody or just kind of ornamental uses, on t-shirts or on websites as kind of discussion points, right? So there are fair use doctrines that should protect all of those speech types of uses, but that's not always the way that trademark owners think about it. Trademark registrations are not supposed to be available for just purchase in gross. Like it's not supposed to be a property right that you can just give somebody money and get a thing and then say, oh, look, now I own this registration that dates back to 1997, right? It's supposed to be that you can only assign rights in a trademark registration if the new party is kind of working in the same category of goods and services as the first user. You can't assign the rights in gross. It has to be with the recipe or with the factory where the things are made or things like that. But again, in practice, that's not always true. And there is sometimes an ability to say, oh, I want this mark and you've already got it, so name your price, right? So there are a lot of ways in which we move away from the model of what trademark is designed to do, which is really focused on competition, into something that looks more like a property right. And it's hard to cabin that impulse. It's hard to kind of rein it in against those kinds of abuses.
So as part of their conservation and corporate philanthropy work, Patagonia funds environmental organizations in Argentina and Chile. But is that enough? What obligations arise when a corporation builds its identity around a place and the meanings attached to it? That brings me to the distinction between legal ownership and cultural stewardship. Trademark law may give Patagonia enforceable rights in the commercial meaning of its name, but cultural stewardship asks a different set of questions about relationship, reciprocity, responsibility, and who has the moral authority to shape how a place is represented. How do you think about that distinction in regards to this case?
Yeah, I think Patagonia is in some ways a good brand for this thought experiment because it has been a brand that gives back and that purports to care about the environment and to be culturally sensitive. And there are a million brands out there that don't do any of that, right? That say, we're here to make money for our shareholders and make our brand sexy and cool and desirable, and that's it, right? This is a brand that has been in some ways a leader on that front. And compare that to like Uncle Ben's and Aunt Jemima's where, you had 100 years of use of this mascot that really wasn't open to criticism until there was a groundswell and until that criticism became overwhelming. So it may be that if enough people are loud enough when it comes to articulating this idea that there is harm being wrought, there's something being appropriated and taken from people who live in this place, maybe the company could be persuaded to invest in that area if it hasn't already, or to share profits in some way. So I'm really glad that you're opening up this conversation.
I recognize that legally, this is purely a trademark infringement case. The court is being asked to decide whether Pattie's use creates confusion, dilutes Patagonia's mark, or otherwise violates trademark law. But I keep coming back to the question underneath that dispute. How was a corporation able to register the name of a real place as a trademark in the first place? And when a geographic name carries the histories, identities, and cultural meaning of communities connected to that place, should those communities have any voice in how the name is commercialized or controlled? Is there room for those broader questions in a case like this?
If Supreme Court is going to rule that corporations are people, then maybe we can open up this question of, if corporations can take self-protective actions and advocate for their interests, then why not rivers and forests, right? And if tribes and kind of communities, and I've seen actually a lot of trademark oppositions, for example, from the Church of Latter-day Saints, right? If there's an ability for groups like that to speak on behalf of an institution, then analogously, why can't we think about a geographic region or a group who lives in a particular region as, also kind of an institution, a community that represents an institution? So I don't know that I'm optimistic about that happening, but I love the idea of it.
It fascinates me that a corporation is legally recognized as a person. It can own property, enter contracts, sue, and be sued. But mountains, rivers, forests, and ecosystems aren't granted the same legal standing. We talked about the rights of nature movement and how it is attempting to challenge that imbalance. But the contrast itself is revealing. Our legal system readily grants personhood to institutions created for commerce, while treating the living world as something those institutions can own, extract from, or build value around.
I think there is a lot of great work on kind of like offensive cultural stereotypes as trademarks and terms and patterns that are tied to Native American tribes or practices, which particularly in the US, right, seems something that deserves attention. Jessica Kaiser has a great paper on this kind of the various ways in which trademark law has ignored and neglected the rights and interests of Native American groups. And this feels closely related to me. So when you're talking about, a river, a mountain range, we're no longer talking about people, but we are talking about a place with a long history and tradition that, of course, has people closely tied to it, right? There's been a lot of work on cultural appropriation in the context of copyright. There have been a few leaders in the fashion industry who have begun to pay more attention to and even collaborate or share profits with groups who originated certain patterns and prints and styles. So I think there's some space here for this criticism and for maybe creative attempts to litigate and move things in the right direction.
The Lanham Act is the federal law Congress enacted in 1946 to establish a national system for trademark registration and protection. It sets eligibility requirements and allows trademark owners to challenge uses of similar marks that are likely to confuse consumers or protect trademarks from dilution. Bringing together pieces from our conversation today, do you think frameworks like rights of nature and trademark law can ever be brought into conversation with each other, or do they operate on entirely different legal logics?
sometimes these things start as kind of very experimental, hypothetical, scholars exploring. This is what we do, right? This is what professors get to spend our summers doing, is really digging deep on these interesting questions that might feel like way outside of the scope of what courts are willing to take on or what agencies are equipped to do, and just kind of keep nudging them into the mainstream. Previously, there was a bar on the registration of marks that are disparaging to particular groups of people. And under that law, groups of Native Americans, for example, had standing to challenge registrations that were offensive and harmful. And there were a number of efforts to do so. But then the Supreme Court struck down the bar on registration of disparaging marks, as well as the bars on registration of scandalous and immoral marks, all based on speech concerns. So all finding that those bars on registration ran afoul of the First Amendment. And I think those same concerns could get in the way of the kinds of efforts that you're describing, right? Consumers don't usually have standing under the Lanham Act either to challenge registrations, though they can file letters of protest. Rebecca Curtin at Suffolk tried to challenge a registration for Rapunzel, as a trademark for dolls, as a relevant consumer. So basically she said, I'm a trademark law professor and I'm also a mom who buys dolls for my child. And so I, want to raise a question about the harm where trademark law kind of enables one company to have a monopoly on a category of stuff, right? It can't be that only one company gets to sell a doll called Rapunzel. That's problematic. But she had a really uphill battle because the Lanham Act, the federal trademark statute, is designed to give standing to corporations suing other corporations. So I'm not sure how a geographic place, even if recognized as having legal rights, could establish that it is being directly harmed under the standard that courts in the USPTO have applied in the past, and without raising this same kind of First Amendment issue. So, I don't know that it's practical. I don't know that it's viable, but I do think it's worth having these conversations, thinking through these questions from different angles, and putting these ideas out into the world.
Are there reforms that would better protect cultural, geographic, or indigenous places and traditions?
Yeah, I think on a kind of a specific level, right? The USPTO has a trademark manual of examining procedure, and it has some power to kind of tweak those rules so that it could say, when an application comes in to register a place name or the name of a holiday or, a term that is important in a particular culture, we're going to give it additional scrutiny, or we're going to consider using one of these bases for refusal if we think there's an important value in play here. Again, you have these kind of First Amendment limitations where the Supreme Court has been pretty clear that, the USPTO is not here to make rulings about speech contained in trademarks, with a few exceptions. So that can be tricky, but those reforms are certainly possible and could be implemented. Lisa Ramsey at San Diego has a great new book on trademarks and free speech, and she makes an argument about marks she calls, I think, inherently valuable marks. And that includes everything from holidays to just widely used catchphrases and slogans. And I don't remember if she talks about geographic terms, but that could certainly fit in there, and how those require additional scrutiny. So there definitely are folks having these conversations and these considerations, thinking about it in a First Amendment, in a kind of harm to speech way, right? That when one company gets a trademark registration and they get to be the exclusive user of a particular term or phrase in connection with a whole category of goods, then what that means is a bunch of others can't use that in the same way or in similar ways, or their speech will be chilled, or their ability to compete fairly will be harmed because that word or phrase is so useful, right? So that's another way to think about kind of place names, is that they belong in the public domain. So maybe Vermont shouldn't be part of the trademark for the maple syrup because we want everybody who makes things in Vermont to be able to put Vermont in a non-trademark way on their packaging, right? So I think, there are a lot of practical concerns there that could translate into fairly straightforward reforms.
Okay, last question. Is there anything about how this case is being discussed publicly that you think is getting missed?
First of all, I love when people get excited about trademark law. So when there is a trademark law story that kind of escapes containment and goes viral and that people are talking about on social media and in the news, I always think that's a lot of fun. Every infringement claim is really fact specific. So this case is not a slam dunk for Patagonia, and it's not necessarily a clear win for Pattie. We only know right now the facts that the parties have made public. So beyond that, there's a lot of speculation, a lot of predictions getting made, but it's hard to say exactly how this will play out. There is room for coexistence. In most trademark disputes, there's an ability for the parties to get together and say, for example, here, okay, Pattie, you can use Pattie Gonia as your stage name. You can sell merchandise as long as it meets the following parameters, right? As long as it doesn't use any logo that looks like the brand's logo with the mountain ranges, or use that kind of font, or maybe use Pattie Gonia in some particular way, right? So that would be my best prediction. I hope the parties are able to do that because it doesn't need to be this kind of zero-sum game where somebody wins everything and somebody else loses everything. And then beyond that, the kind of duty to police idea that we talked about, I think that's something the public is getting wrong. And these questions that you've opened up today about geographic terms and about who deserves the right to use and control those and whether it's really harmful for those to be trademarks at all, I think that's a great kind of add-on here. That's something the public isn't really thinking about that they might be open to thinking more about.
In the late 19th century, the emerging states of Argentina and Chile portrayed Patagonia as a desert, an empty landscape awaiting civilization. But as is the case often in stories such as these, that was far from the case. Patagonia was and remains home to indigenous peoples with long-standing relationships to the land. However, that mythology of desert land helped justify the conquest of indigenous lands and the killing, enslavement, and displacement of thousands of people. More than a century later, the image of Patagonia as untouched wilderness remains commercially powerful. It sells adventure, the fantasy of escape, and a landscape seemingly unburdened by history, politics, or people. Patagonia Inc. did not create that mythology, but it has profited enormously from it. Through decades of marketing, the company transformed the name of a real place into a recognized brand. Seen in that context, the trademark dispute raises a question larger than who owns a word and how it is used. It asks who has the power to define what Patagonia means and whose histories disappear when one version of that meaning becomes legally and commercially dominant. Communities whose histories give a place its meaning may have little formal say in how its name is being commercialized, even as corporations gain the legal power to exclude others from using it. And perhaps that is the larger lesson here. Ownership is not the same as relationship. Brand protection is not the same as stewardship. And legal rights do not resolve the ethical question of what we owe to the places, people, and histories from which value is drawn. Thank you to Professor Alex Roberts for joining me in conversation and pushing the bounds of trademark law to reimagine and explore what could be possible. Art of Citizenry is entirely listener supported. Please consider contributing to artofcitizenry.com/support. Subscribe, leave 5 stars, reviews, and of course, please share these conversations forward. Thank you to our producer, Aliana Ray, and editor, Stephen Blevins. Original theme music by Katrina Zembrak.